All right, court will find that the state is in compliance with discovery. Mr. Rendone, did you review the document entitled Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Hello.
Good afternoon.
Hello, afternoon. How are you doing today?
Nervous, but here we are.
Okay. All right. The court is calling 2024 CR 2339D State versus Matthew Rendone. Can I have parties announce?
Megan Galloway for the state.
Victoria Cruz on behalf of Raymond Martinez for the defense.
All right. And are you Mr. Matthew Rendone?
Yes, ma'am.
All right. Do you have any objections to this attorney standing in?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor. Defense is satisfied.
All right. Court will find that the state is in compliance with discovery. Mr. Rendone, did you review the document entitled Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Today in courtroom 2339D, a high-stakes case unfolds with a charge that could carry up to 20 years behind bars. The defendant, Matthew Rendone, stands accused of aggravated assault with a deadly weapon, a second-degree felony that changes lives in an instant. The courtroom is tense, the judge is sharp, and the plea deal hanging in the balance is anything but simple. But it's not just about what's said, it's about what's unsaid. What does no contest really mean in a case like this? Why is the state abandoning one of the charges? And most importantly, with children at home and a stock investing side hustle, is Rendone truly ready for what's next? Buckle up, because this isn't just a sentencing hearing. It's a pivotal moment in a man's life that could echo far beyond these courtroom walls.
Your Honor, we move to proceed on count 1 and waive and abandon count 2.
No objection from defense.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right. You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendone, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. If the court finds that a deadly weapon was used, there's going to be an affirmative finding of deadly weapon. The state recommends deferred adjudication, and there's restitution, if any, to Oscar Del Fierro. Fierro?
Yes, Your Honor.
Yes, Judge.
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Oscar Del Fierro, Anthony Cochran, Richard Campos, and the hostility management course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead to count 1? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states 1 in attachment.
No objection from defense.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will
Let's pause right there. What we're seeing is a textbook example of a deferred adjudication plea. And here's why that matters. Rendone is not technically being convicted today. Instead, if he follows all court-ordered conditions over the next 5 years, the charge can be dismissed without a conviction on his record. But, and this is a big one, if he slips up, that deferred deal gets revoked, and the judge can sentence him to up to 20 years. This kind of legal strategy is often a lifeline, but it also comes with a ticking clock and zero room for error. Now ask yourself, is Rendone fully aware of the razor's edge he's walking on?
be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right. Are you currently employed?
Yes, ma'am.
What do you do?
My family has businesses. I do stocks on the side.
You say
Mostly-
stocks?
Yeah, like stock market. I'm an investor.
Oh, okay.
I do a lot of entrepreneurship. It's
Okay.
that category of work.
How's stock investment going?
I don't like to get political with it all.
No, no,
It
no.
affects it, but it's good. I make good percentages yearly. Good point.
No, I ask that. I have friends who do the stock market and they're always coming to me and I'm like, don't get married to the stock. Don't marry it.
It's a lot of discipline.
Oh, it is. All right. Do you have any children?
Yes, ma'am.
And what are their ages?
I have a 4-year-old son and a 3-year-old daughter.
Okay. All right. This is what the court will do. The court is going to sentence you to 5 years deferred adjudication. There's an affirmative finding of deadly weapon. There's to be regular reporting by Zoom or in person, regular random UAs, $2,000 fine probated. There's to be restitution, if any, to Oscar Del Furio. State, when do y'all want the restitution hearing set? All right, can I have 30 days for a restitution setting, please?
Yes. If I could just pop up.
Sure. And it may be a restitution amount that they agree on, but I've learned that when you don't set a restitution hearing, it just floats out there.
Yes.
And so I want you to be able to know what the amount is.
Judge, if you give me just a second, I'm looking up another court paper for Megan.
Okay.
I'm just trying to get it like that.
Oh, no problem. All right, while they're doing that, I'll continue. So there's going to be 200 hours of community service restitution. I'm going to order parenting classes.
Now here's where the real-life consequences come into play. Money, restrictions, and surveillance. A $2,000 fine, no contact with multiple individuals, hostility management classes, random drug tests, and 200 hours of community service that could only be reduced after parenting classes. The judge is building a sentence not just to punish, but to reform, especially for someone with 2 toddlers at home. But the mention of no contact with victims and others hints at something deeper. Perhaps tension, threats, or a volatile past. This isn't just a slap on the wrist. It's a full lifestyle overhaul, with the court watching every step.
Once that's completed, the community service will be deemed satisfied. People always wonder, why do you order parenting classes? And the reason why I do it is because when people are making these choices, they need to think about their children as well. What would happen if I go to prison? And, they're not really thinking about that. They're in the heat of the moment. And let me do this. There's going to be parenting classes, 100 hours deducted for the parenting classes. And then I'm going to order the hostility management course that was recommended. And then once you complete that, the remaining 100 hours will be deemed satisfied.
Thank you, Your Honor.
There's to be no contact with Oscar Del Furio, Anthony Cochran, and Richard Campos. And there is to be proof of employment within 30 days, no employment as a home health care provider or with minors. Probation, is there anything? Thank you. Field visits 1 time per month for 5 months. Anything else, probation? Is there anything else you need from the court in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Do we have a date?
July 24th.
All right, so what's going to happen on July 24th? We'll be back here, and that's for us to get an amount of restitution that is owed, and your attorney will have a chance to either object.
And here comes the emotional climax. The judge leans in, not as a jurist, but almost as a mentor or parent. Her words hit hard. If you end up firing it and it hits someone, there's no turning back from that. This isn't legal rhetoric. This is a reality check. And the most powerful moment? When she talks about the kids. Where's Daddy? A haunting reminder that punishment isn't just felt by the defendant, but by the innocent ones waiting at home. It's courtroom drama at its rawest, and it leaves one burning question. Will Rendone take this second chance seriously? Or is this just a pause before the fall?
To that amount, agree to that amount. Do you understand?
Yes, ma'am.
So let me explain something to you. When people bring out guns, guess what? If you end up firing it and it ends up hitting someone, there's no turning back from that. You understand? So you're going to have to start thinking and putting your children at the forefront of your thoughts in everything you do, because everything that you do ultimately ends up impacting them. If you go to jail, even if you're in jail for 30 days, getting a bond, it's where's Daddy. If you end up going to prison, it's where's Daddy. And then that snowballs other thing, because sometimes you have women who will wait for you after you get out of prison. Sometimes they don't. And you know what that means? That means that somebody else that you don't know is raising your child.
Yes.
All right. If you need anything, let probation know. If you feel they're not addressing it, you can always come back to the court. Okay.
Thank you.
All right. Good luck to you.
May we be excused, Your Honor?
Yes.
Thank you.
Let me put this in the system. Everything must go in Odyssey now. And Odyssey is slower than my typing.
Figure out the first one, 2 more, please.
Okay.
And with that, Matthew Rendone walks out. Not free, but on a very thin line. 5 years of deferred adjudication, a confirmed use of a deadly weapon, 0 contact with multiple people, parenting classes, and proof of employment with strict conditions. The court may have shown leniency, but make no mistake. This is a structured sentence loaded with accountability. If he slips, the full weight of a 20-year sentence looms. This case isn't just about guilt. It's about redemption and the heavy cost of choices made in anger. So what do you think? Did the court get it right? Should Rendone have gotten prison time, or does this path give him a real chance at change? Let us know in the comments. And if you found this case as shocking as we did, make sure to hit that like button. Share your thoughts below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.